has executive responsibilities for 4 organizational units in the Amnesty International USA. He heads the Washington, D.C. office and is a focal point person for decision-making on how AI USA engages in policy discussions in Washington, D.C., and how it responds to developments that are influenced by U.S. foreign policy. And of course, we know him in the policy community for his prior role to this, serving as the policy director for East Asian and Pacific Affairs for the Democratic staff of the Senate Foreign Relations Committee and advising Senator Kerry in that capacity. And finally, we have Dr. Jung-Hyun. He's a senior researcher fellow at the Korea Institute for National Unification. His interests include international law, international organizations, refugee laws, and many other things. And he's an advisor to the Korean Ministry of Unification, Foreign Affairs, Trade, and National Human Rights Commission of Korea. And we welcome all 3 of them today. We will start with you, Dr. Lee, 10 to 15 minutes, and then we will proceed down the table. Thank you.
Well, when the organizers of this conference approached me, they were not specific about what I was expected to write on. But I presumed that I was invited because I was expected to draw lessons, practical lessons for transitional justice in North Korea on the basis of my first-hand knowledge of the South Korean experience in transitional justice. But apparently I was mistaken. If I had known that we were allowed to write about South Korean transitional justice, I would have traded places with Dr. Baek Bum-seok, who presented his paper in the last section. But anyway, I will try to some practical lessons from the South Korean experience. Before I start, to put the South Korean transitional justice in perspective, I would like to point out 3 things. First, in South Korea, at the time of democratic transition in 1987, 1988, there was a leader, if any, public clamor for justice, in stark contrast to some countries where such a demand was one of the facilitating factors of democratization, for example, in Argentina. Second, since the democratic transition, however, there was a tremendous progress toward truth and justice. 2 former presidents and several others were brought to justice on the charges of disrupting the constitutional order and were convicted to jail terms. Nearly 20 truth commissions were set up to deal with virtually all dark chapters of contemporary Korean history. Thus, the South Korean transitional justice was primarily concerned with the truth-seeking and reparations, but spiced with some semblance of retributive justice or criminal justice. Not only were the human rights abuses under the immediately preceding authoritarian regimes redressed, but also some instances that go as far back as 100 years have been re-evaluated in the case of South Korea. Thirdly, all these Koreans achieved, accomplished on their own initiative, without the prodding or assistance from the outside forces. So it's quite a contrast, strikes quite contrast to what happened in Cambodia or East Timor. Having said this, I must hurry to add that there were problems as well. And many of these problems were related to the way transitional justice was approached in South Korea. Well, the most prominent feature of the South Korean approach to transitional justice is what I call the commissioning of the past. Among the different means of achieving transitional justice, South Korea relied preponderantly on truth commissions. And the post-democratization administrations set up, as I said, nearly 20 commissions dealing with the so-called past affairs. However, the government and the political parties, politicians had no blueprint concerning the matter. The whole process was just muddling through, responding to particular demands from a particular stakeholders and the political constellations of the time. And this is clear if you look at what the truth commissions were expected to do. Except for the TRC on which I served, the so-called past affairs-related commissions dealt with a single incident or a single type of incident. So these commissions were responding to particular demands from particular group of victims or families. And this muddling through approach to transitional justice resulted several problems, such as inconsistency across the commissions, overlap in scope of investigation among the different commissions, and thereby leading to waste of resources. Some cases were investigated in one commission after another, as many as 3 times, 4 times. Judging from this experience, I would say a blueprint of some sort is needed when approaching the North Korean transitional justice. Depending on how transition is made, we can expect a few different scenarios, but for each of these scenarios, we should have some contingency plans. And each contingency plan must be as clear as possible about goals, scope, and means. In South Korea, ambiguity in the laws and the executive decrees governing the past affairs commissions, and inevitably, a large room for discretion caused many problems, and this aggravated the already high level of politicization. I will get back to that later. And if you read my paper prepared for this conference, where I listed several instances problems that were caused by ambiguity. And sometimes even the scope was not clear. Sometimes TRC was to investigate the human rights abuses until the end of the authoritarian rule, but when the authoritarian rule was over, was not clear in the executive decrees or laws. But I want to emphasize that these ambiguities were sometimes due to legislative lapses. But more often, these ambiguities were intentional on the part of the lawmakers. Many key terms were left unspecified to wade through the controversies in the lawmaking process in order to reach a compromise and pass laws. Temptation for ambiguity, I would say, will be stronger in the case of North Korean transitional justice, against which we should stand guard. Looking back, the works of South Korean commissions were highly politicized. And as I said, ambiguity, I just mentioned, aggravated the problem. In controversial cases, I can tell you this from my own experience, commissioners could rarely reach consensus even after several rounds of lengthy discussion and deliberation and persuasion. In these cases, eventually the commissioners voted. And they voted, almost always they voted along their political fault lines. So here the so-called verified truth were none other than voted true. Well, it has little relevance to the facts. Truth were not corresponding to facts. Truths were corresponding to political positions of the commissioners. Thus, because of this change of governments and the changed ideological composition of the commissioners sometimes resulted in radically different decisions on the similar cases. When it comes to North Korean transitional justice, we have a reason to believe that the level of politicization will be even higher. And opinion polls show that the South Koreans are sharply divided and deeply divided in their attitudes and feelings toward North Korea. Besides, investigators of the truth commissions were largely of the so-called progressives who were soft on North Korea. And these agencies were captured by the progressives. Well, the agencies in charge of North Korean transitional justice may be captured by the same progressives. Or conversely, these agencies may be captured by the so-called conservatives who are very critical of North Korea. So in either case, their investigations, their assessments may not be objective. So we should try to avoid politicization. And one way of depoliticizing the issue would be engaging the third parties, international community and relevant international institutions or organizations. We do not like that. But to avoid further politicization, that may be necessary. Well, Koreans are very proud of the fact that they dealt with the past wrongs with their own hands. But now it's time for us to consider engaging the international community, international organizations. Okay. As for scope, transitional justice often concerns primarily the human rights violations perpetrated in the immediately preceding authoritarian regimes. But South Korea, as I said, dealt with some past affairs that go as far back as 100 years. Well, North Korean transitional justice may not go that far back, but still, I think that we need to go back back to 1945 because there are some very prominent issues that started from that period. Without handling these, okay, then we need to go back. So what I want to suggest, well, you may read my paper. Well, as for justice mechanisms, instead of focusing on truth, in the case of the North Korean transitional justice, we may also use the trial mechanisms, vetting and lustration, not only for symbolic reasons, but also for the full-blown justice. And finally, I want to mention about the significance of the securing public documents kept in the North Korea, well as securing the Stasi files in East Germany. One of the success factors, one of the factors that contribute to the success of the South Korean Truth Commissions was the availability of the meticulously kept records. Well, the authoritarian regimes may have crooked laws, may abuse the laws, but still, it was ruled by law, if not rule of law. So the whole abuses had taken place. within the legal system with the recourse to legal procedures. So all the investigation records, all the interrogation records, all the trial records were there. So in the case of transitional justice, I believe that Dr. Yoon is making a great contribution in keeping records of the human rights violations. But in addition to that, if we can find ways to secure the records kept by the North Koreans, that would be the best. Well, the professor mentioned in the last section that, well, one possible way of securing that is bribe them to sell those the records to us. Okay, thank you very much.
Right. Thanks so much. I'm shocked. I'm appalled that you would suggest that legislators might inject a degree of ambiguity on purpose into these commissions for political purposes. I've never known a legislative assistant to do such a thing. I want to thank the Asan Institute for inviting me here this afternoon, and I'm sorry I wasn't able to attend yesterday, but I know my colleague Rajiv Narayanan from Amnesty International was here, and you heard from him, I hope already, moving stories and analysis about the human rights challenges in North Korea. And I've been asked to build off of these presentations and talk about justice. And in doing so, I want to again commend the Asan Institute for thinking ahead. My two best professors in graduate school, Ernie May and Dick Neustadt, wrote a book called Thinking in Time, which is about preparation for the unknown future. And the work that is being done here and in the coming years to prepare for justice is very important, and it represents the best example of thinking in time. I'm going to draw on my experiences from two places, from Amnesty International and as a refugee officer on the Cambodia border. And maybe this is more appropriate to the panel that preceded this one, but I will try to integrate it into this panel's purpose. We're supposed to be presenting ideas on transitional justice. Anyone who's familiar with Douglas Adams, you know what the answer is. It's 42. Unfortunately, we have to get the right question. So let me talk about the questions that I learned from Cambodia. Peace building, reconciliation, and transitional justice is incredibly case specific. Right? It's going to depend not just on the country, but also the scenario by which justice comes. Other people have made that point. In the case of Cambodia, that I know well, we were speaking of a shattered country, devastated in every way by Khmer Rouge atrocities that had laid waste the intelligentsia, either killing them or forcing them to flee the country, as well as shattering the institutions of the state that could have provided mechanisms of justice to the Cambodian people. And I begin with an assumption, which is however grim the conditions are in North Korea. I've been there 5 times. I've seen the grim conditions for myself. They will be better than the conditions facing Cambodia in 1993 upon the introduction of international peacekeeping forces, a UN-sponsored election, and the establishment of truth and justice mechanisms in Cambodia. That's an assumption I have. I hope that I'm right about that. Now, as others have said, that justice will be shaped by the circumstances. And so in the case of Korea, there will be capacity. We know there will be justice capacity, frankly, in both North and South, upon the decision having been reached to seek justice. And the question will be, one, for the Korean people, do they believe that the possession of that capacity means that they must go it alone? Or will, as Professor Lee has alluded to, will there be some advantage to be sought by involvement of international jurists, international mechanisms as part of the process? That's going to be a decision that the Korean people make for themselves. Knowing the Korean people a little bit, I will be surprised if they are eager to seek outside counsel. They may seek some outside advice, as they are doing today, but they're at the end of the day, they may not welcome outside direct authority and involvement. We'll have to wait and see. Now, the international community can play a role nonetheless, whether it's a formal role or an informal role. In the case of Cambodia, of course, they set up a hybrid international tribunal, combination of international jurists and local jurists, to try to bring to justice some of the senior officials from the Khmer Rouge period. And a conscious decision was made, as will have to be made at some point in Korea. At what level does your scrutiny stop? Are we going to hold only the most senior officials responsible for crimes against humanity? Are we going to hold the prison guards responsible? Are we going to hold the average policeman or the average informer on the streets responsible? And responsible how? Responsible in a retributive criminal justice mechanism, or responsible through some other mechanism? These are decisions that will have to be made. In Cambodia, it's been a hybrid. The one conviction that has been reached was for Duc, the prison master of Tol Sleng prison. And for those of you who have been there, you can feel, as I do, a certain satisfaction at him being held accountable. There is now a process underway to hold senior Khmer Rouge leaders responsible for their crimes against humanity. But the clock is working against us. One of them already, two of them, Pol Pot and Yang Sari, already passed away. Others in their late 80s, the trial grinding along in its slow way. But nonetheless, I disagree strongly with those who claim that the Khmer Rouge tribunal process has been a failure. And I think that there are lessons here for the future of the Korean Peninsula. To declare it a failure is to misunderstand its contributions to the principle of accountability in Korea. The Khmer Rouge Tribunal affirmed this most fundamental principle, that there must be a measure of accountability, even 40 years after the fact, for the human rights violations that the Khmer Rouge perpetrated upon 8 million Cambodians. It also has served to be a very important education tool. Hundreds of thousands of Cambodians have actually attended the trial. Millions of Cambodians have seen it on television. 50% of the Cambodian population is below the age of 30 and have no first-hand recollection and memory of the Khmer Rouge period that resulted in the deaths of so many Cambodians and the persecution of their parents. So for them, this tribunal is not just about retributive or consequentialist justice. It's about education. It's about learning who they are and where they have come from and what their country has been through. And that will be an important focus, I believe, of any transitional justice system in Korea. Just because the North Korean people are living through the suffering today does not mean that they have a clear understanding of it, of its national scope, or of why. And all of those questions, I think, can be addressed in part by transitional justice in North Korea. Thirdly, there's an element here about education about what justice is and what it looks like when it's fair. Because the Cambodian court system is fundamentally flawed, and this hybrid tribunal system is the best example of justice that most Cambodians have ever witnessed. And by seeing representation and lawyers and due process and standards of evidence and transparency, the Cambodian people are getting a tutorial on what justice looks like. And that process is almost as important as the verdict, witnessing the process of justice. Now, North Korea is not Cambodia. So upon unification, again, as I mentioned, the South Korean state is going to have the capacity to affect justice. And even if there's not formal unification, North Korea, in theory, would have, under a new system, would have the capacity to undertake a process of justice. Now, what will it look like? Again, there's a couple of different goals in mind. One is the retributive, criminal liability. And the other is more restorative justice, right? The reconciliation piece. It's Amnesty International's view that any truth and reconciliation restorative justice process must not prevent accountability and criminal responsibility for crimes against humanity, genocide, the gross, systemic, widespread crimes that we know are happening in North Korea today. That may be a somewhat controversial notion, but that there ought not to be amnesty. Amnesty's view is there ought not to be amnesty for such crimes. Right? Now, I'm not a lawyer, and under the International Criminal Court and other international norms, there are ways in which accountability through a local process can be judged to immunize those suspected of criminal wrongdoing from further prosecution. But those are only under certain circumstances where, in fact, justice has been done. Now, I appreciate that Professor Yi has already shared his lessons from the Republic of Korea process that they've undergone. One of the important things that process led to was the notion that there ought not to be a statute of limitations on certain crimes against humanity. And that's another important principle that should guide the process of transitional justice for North Korea. So if the goal is accountability, holding responsible those guilty of crimes against humanity, no impunity for crimes of such widespread, systematic nature, what form does accountability take? Amnesty International recognizes that non-juridical processes may supplement or augment criminal prosecutions. And in fact, for the vast majority of the cases that are likely to be considered in a transitional justice, that's going to be the way it happens, because it's simply not going to be practical to have 100,000 or 200,000 criminal cases grinding their way through some sort of judicial mechanism in a transitional justice environment. And this is okay, because again, the goal of the non-judicial processes is going to be about education. It's going to be about fostering reconciliation. It's going to be about giving a platform for the victims to be heard, for their voices to be heard. But who will decide? And this is how I want to close my discussion with you this afternoon, is who is going to ultimately decide what this reconciliation judicial transition justice mechanism looks like, and what criteria, what benchmarks should they follow to establish this? Because it's my belief that as important as the judgments may be flowing out of any criminal proceedings or out of any truth and reconciliation commissions, as important as those judgments are to establishing justice and accountability and affirming the human dignity of the Korean people, perhaps as important or even more important will be the very process by which those truth and reconciliation and judicial accountability mechanisms are established. Because as Professor Yi has so accurately captured, and as Huntington has written about, at the end of the day, retroactive justice is shaped almost exclusively by politics, right? I mean, that's the reality that we're dealing with. It's shaped by politics and the distribution of power. And so Amnesty International's guidance to the people of Korea as they think about this is to consider the process by which these commissions or courts are going to be established. That process should follow 8 benchmarks. First, they should be established by law, right, after a period of public consultation. Second, they should be clear, but the mandate should be flexible enough that it does not supplant the formal judicial system. Third, the process should be officially embraced and endorsed by the state, not just left out there as some kind of a independent civil society initiative designed to solve the problem. The state needs to own it. They need to endorse it. The results of it need to be officially proclaimed and published and disseminated. Fourth, any such processes should meet adequate standards of due process. That applies not only to formal judicial mechanisms, but also to informal truth and reconciliation processes. Fifth, they should provide adequate protection for victims, witnesses, and their families, which could be very important in the case of North Korea. Sixth, they should be open and transparent. Seventh, they should be independent, ultimately, of the government and political forces. How to accomplish that independence, whether it's by inviting international jurists, in the case of Hong Kong, the Supreme Court of Hong Kong actually has people serving on it who aren't even citizens of Hong Kong or China. That's how far they take their notion of judicial independence in Hong Kong. I don't know. It'll be up to the Korean people to decide, but it should have independence from the government and political forces. They should have necessary expertise and investigative powers. And finally, they should have the power to make recommendations for reparations and compensation. So to close, we're faced with a future of transitional justice in Korea that, of course, is a bit murky. We cannot predict the mechanism by which justice will be arrived at. And the people of North Korea, therefore, should be understood to be learning as much from the process of establishing justice as they are from the outcomes of it. I hope that the situation in North Korea will not be what many of my friends in China say to me when I ask them about the notion of either transitional justice or accountability or retroactive justice for Tiananmen Square. And when I ask my friends in China about that, and I say, when will there be justice? They say, justice will be arrived at through a series of state funerals. I would hope that's not the case on the Korean Peninsula, and that for the Korean people, they will have opportunities to seek justice of their own design. Thank you.
I never said to let the international community take care of the transitional justice in North Korea. I said engaging international community.
That would be good.
You may be right. Koreans are too proud to let others do that.
Dr. Jung.
Yeah, first of all, thank you for inviting me to this very prestigious and meaningful conference at this crucial juncture around the Korean Peninsula. I actually not an expert on transitional justice, but as an international lawyer and somewhat specialist on North Korean human rights issues, I prepared my presentation. But the problem is most of what I had prepared have already been discussed during this very fruitful 1.5 day conference. So now I'm in some transitional period. So how can I make it? Just follow my script or not? Even the order of presentation in this session is changed just before the start of this session. So my script said that as the last presenter, but not last, but second to last. Yeah. Anyway, I will go. Yeah. While I'm coming here from Seoul, I watched a movie entitled Lincoln. Yesterday we already talked about that a little bit. Why are you laughing? The well-made, the well-made film, I think, I gave me two important points to consider. First, contrary to his firm resolution towards the abolition of slavery and the surrender of the South, Lincoln's plan to rebuild the country was much softer, in that he seems to have concentrated more on peace and charity rather than punishment. I'm not 100% sure that that could be directly applied to the Korean situation, but anyway, this may actually give us some practical implications. Second, Lincoln died on the 15th of April. I didn't know about that. The date is my first working day at the Korea Institute for National Unification. What a coincidence. So now I feel myself more responsible for my work for Korean unification and substantial integration as the successor to Lincoln. Yeah. Sorry for a big jump. Yeah. So
it's
now,
also the day Caesar was killed.
Yes.
Eyes of April.
Yeah. Yeah. So let's start. So there are so many common points we already discussed about. So I don't want to repeat here. So now you know where about what transitional justice is, and you already know there are some main mechanisms in implementing transitional justice, such as not only criminal prosecutions, but truth-seeking and reparations to victims and institutional reforms as well. So this, as we already mentioned, may be applied to the Korean situation after the reunification. Even after two Koreas finally achieved their long-awaited political unification sometime in the future, there will be more important and difficult tasks of achieving substantial integration between long-time divided societies and peoples. But no one knows when the national dream will come true and what type of unification will occur. We have already discussed about that. There are many kinds, from the consensual basis unification and very sudden absorption to some events, including armed conflicts, either contingency or even a full-scale war. But in any scenario, how to utilize the transitional justice concept and mechanisms, and how to balance among transitional mechanisms could be one of the key policy challenges to face for more successful and substantial reunification on the Korean Peninsula. So as we already discussed at the second session yesterday, we know very well about the very dire human rights conditions in North Korea currently. So international community acknowledged it continuously by adopting respective resolutions by the UN Human Rights Council and General Assembly annually. And there are some new developments recently. Since last year, they adopted the North Korean human rights resolutions by consensus without a vote, which clearly showed that how the international community worry about the situation in North Korea. And another one is the establishment of the Commission of Inquiry. It is very unique because most previous cases, the COI were established after to deal with the civil war situations, including some armed conflicts. So, is peacetime crimes against humanity matter? If we see the North Korean COIs, so it is somewhat unique. Yeah, technically, it is somewhat wartime we can consider, but actually it is peacetime. Yeah, so it is really unique development about that. So there are many kinds of human rights violations in North Korea. I don't want to repeat it again here, but the most important part could be about the political prison camps, because it provides a comprehensive set of many kinds of violations, from civil and political rights to economic, cultural, and social rights. And according to my institute research last year, currently there are 5 political prison camps in North Korea. According to our research, last year the number 22 Hwaryong political prison camps has finally been closed. And the total number of inmates may be around 100,000. But previously we know that 150 to 200,000, but according to our research, it may be less than that number. So the reason may be, as yesterday Shin Dong-hyuk pointed out, because of the high death rate inside the political prison camps, although while no mass inflow recently. Anyway, turning to transitional justice problem, I also agree that all the persons who are responsible for such crimes, such as political prison camps related crimes, basically need to be brought to justice. Even compared to the East German case, the North Korean abuses are much more serious. In this context, previous discussions in South Korea have mostly focused on criminal punishment after the reunification, mainly led by the Ministry of Justice. And it also contains some victims, reparations to victims part, and also some structural reform part. But the main point is criminal punishment, because you know the character of the Ministry of Justice. However, to start with a clean slate with criminal methods seems to be neither practicable given the lack of substantial information and evidence. We may have another information from the official archive from the North, but I don't know the result. We may get or we may not get. Yeah. From the current status, it is not so practicable. So when the COI visit South Korea to get some more very practical and concrete information, including some information about perpetrators, they may face some difficulties. For example, last March in Geneva, the current special rapporteur, Mr. Darsman, asked me that, do you know who are the head of each political prison camps? His concern is about that, who are managing that currently. But my answer is no. No, managed by some, what organ of the North Korean bodies. But I don't know the name of the political prison camps has. But as Dr. Shin pointed out earlier, as some cumulative evidence, it may be utilized for the prosecuting the high-level officials anyway. But anyway, currently we have some limitations to get some relevant information and evidence. And to start with a clean slate is also desirable in view of social integration in some respect. In addition, from the unification policy perspective, this principled but rather strong position may send a negative message on unification to most North Korean elite groups and even some middle-class people, whose role can be crucial during the unification process. In fact, there are many press reports on the North Korean elites' preference of China over South Korea as their partner, as most of them would be convicted criminals of human rights abuses after the unification. All these points considered together, the scope of punishment needs to be limited properly. Yes, so it depends on situation, the mode of unification and the general consensus among the peoples. But anyway, we may need some limitations. So my moderate suggestion about the criteria of the criminal prosecution could be some international criminal standards, such as international crimes against humanity, genocide, and war crimes. So crimes against humanity is maybe most relevant, especially about the operating political prison camps. About the venues, yes, there are many options from the ICC, ad hoc tribunal or hybrid tribunal, to the domestic criminal courts. I'm not so pessimistic like Professor Lee. Yeah, we can do it. Yeah, we can. Yes, from the contemporary perspective, we have many disadvantages. We don't have enough ability maybe, but from the historical perspective, we are learning and developing. So I believe in the future we could be better. Yeah, and also considering the principle of complementary of the ICC, the domestic courts may be more proper to deal with the North Korean human rights cases. For example, the South Korean National Assembly already enacted an act in 2007 for implementing the Rome Statute of ICC in domestic courts. But there are some technical barriers, such as statute of limitations and retroactive punishment problems. But I also hope that this could be cured by way of enactment of new special law and harmonized interpretation of relevant laws, international and domestic. Oh, how much? Already done? But
30
the
seconds.
second part, sorry. Oh. So, with this criminal prosecution, we also need to consider properly about utilizing the TRC and also other mechanisms. But TRC's function is maybe originally to find the truth and record it, but also, as Jannuzi pointed out properly, it may be related to the reparation to victims and also to institutional reforms, including so-called vetting and restoration. So we should consider it properly. Yeah. So now I conclude my presentation. The process of transitional justice is really dynamic since several mechanisms can operate simultaneously. They are also closely interconnected one another, not isolated. How to balance between those approaches, in particular between criminal prosecutions and truth-seeking, reconciliation, or between pursuing justice and facilitating national integration, national unity, will depend on the actual situation surrounding the prospective unified Korea. If people's general sentiment permits, prosecutions may be limited to severe international crimes, such as crimes against humanity. Instead, the role of a Truth and Reconciliation Commission and the effect of amnesty need to be given a serious consideration. Also, a database of human rights violations can be used as a source of reparations to victims and determination of eligibility for public officials, in addition to as evidence for criminal punishment. No one can predict the future of the Korean Peninsula. However, considering the current dynamics within and surrounding the Korean Peninsula, more detailed research and further careful examination on the applicability of transitional justice to the Korean situation is clearly necessary. Thank you.
Thank you very much. I am at the unenvious position of standing between you and Memorial Day weekend, so I will keep my remarks short. And like Dr. Joe, I am not a transitional justice expert. In fact, I'm a political science policy wonk here in Washington, D.C. And so rather than offering up any practical solution, I would like, as the last person to speak in these last 2 days, to actually kind of look back and highlight some of the important themes that came up, as well as perhaps some gaps in the discussion that I've noticed. And then, so take it at the 30,000 feet. We started at looking at the forest, we looked at the trees, and now we're back at the forest again. So, first of all, I think most speakers caveated their. So I have 3 basic points. Most of the speakers caveated their statements by saying how transitional justice can be dealt in a post-unification era is very much a political question shaped by how reunification happens, right? I think that is the most fundamental question that needs to be dealt with before we deal with the transitional justice issue. Because if we're faced with a complete collapse of North Korea, transitional justice, how we approach that is very different from if we approach a North Korea that we have to negotiate in a power-sharing situation. Or perhaps even dealing with a civil war situation with warlords. Because without this context, all of our discussion, we may be talking and thinking about what we hope for in this post-reunification era, but maybe not pondering the important and difficult questions and difficult situations that we may face in the case of different types of reunification that we hope not to happen, but it may likely happen. So and also the difficult question of transitional justice if reunification does not happen. What do we do in those cases? In that case, it would probably be called status quo justice. I don't know, a new name like that. So one of the questions to deal with that, I would recommend to the Asan Institute, maybe in the light of taking a tip from Hollywood. In the season of prequels and Star Wars and Star Trek, maybe we can have a prequel conference looking at how unification will happen and what are the likely paths in unification to be achieved. And, and taking a page from the recent Star Trek movie, we can call it Into the Darkness, Pathways to Korean Unification. And then begin our discussion of transitional justice, because it will set the parameters of how transitional justice needs to be achieved. The second part of this is an important point that I think Andrew Nastiosis brought up during the first panel, which is that as we talk about globalization of transition justice, human rights, becoming important in North Korea, that we forget that North Korea government and society is a learning society. They are leaders that are watching the international community. And working on the North Korean nuclear weapons issues, we know this very clearly, that the North Koreans are always watching what the international community is doing. And they take a page out of Libya, knowing that if you give up your nuclear weapons, your country is going to fall. And therefore, giving up your nuclear weapons has become an important issue that perhaps the North Korea are not willing to talk about anymore because of that lesson. And this is important because the problem we face is that in North Korea, because of the length of time that has passed, we're talking about 2 generations of North Korea, right, under an oppressive regime. The second point is that 3 generations, excuse me. We also need to remember what kind of government system North Korea exists. My old professor Alfred Stepan and Juan Lintz called North Korea a totalitarian sultanistic society, meaning anyone and everyone who is an elite because they have some loyalty to the family. And so therefore they were involved in some capacity to ensure that that society and that system existed. Therefore, after 3 generations, all the elite's hands are soiled. No one is innocent. And 3, the level of atrocity that we're talking about. In the last 2 days, we heard about some of this atrocity, prison camps, starvation, and so forth. And can you imagine, once we get into North Korea and open up the archives, of what those archives will look like? 60 years of atrocity. And so the issue is the bottom line is everyone is somehow guilty, and therefore they're looking to a future of a reunified and how much they will be implicated. And our discussion actually in the international community may be continuing to scare them and disincentivizing the idea of reunification. One of the country or one of the players that we have not really talked about too much except a little bit is actually China too as well. The question is we all know that China plays an important role in propping up North Korea. And once those archives are opened up, how much will the Chinese be implicated in this situation? So the question is does the Chinese have an incentive for reunification? The other point is to turn the focus on South Korea too. And many of the panels discussed about South Korea's democratic process and how to handle transitional justice and so forth. And the idea of people will probably demand immediate justice, no time. You need results immediately. We need to deal with these issues. And once the archives open up, that perhaps the starvation period, for example, in the 1990s was not 200,000 deaths, or maybe in the millions of deaths, how will the South Korean society react to that? The level of atrocity is so great, it may demand some kind of result. And how will the South Korean democracy deal with that situation? And can they deal with such a situation? My third point and final point is looking at South Korea's own reunification strategy. Is South Korea's current reunification policy limiting how far we can pursue transitional justice in a reunification period? Because if you look at all the reunification strategies of the past South Korean regimes, it's a functionalist idea of reunification. You start with humanitarian assistance, some cultural exchanges, some economic exchanges, and then eventually a vision of Korea of some kind of political integration. But if you think about it, we are creating a reunification environment that is empowering the very people that we are made eventually have to put in the courts and will be implicated in these transitional justice periods. It's a power sharing mechanism, and in power sharing mechanisms, transitional justice is very limited. So the question is our reunification strategy even limiting what we can do in a post-reunification period when dealing with transitional justice? It's just a question I toss out there for all of us to consider. So finally, just in conclusion, the 3 points that I've highlighted here is that we are to deal with transitional justice. We are dealing in the aftermath of a major process. So the first point is, what is that process and how is it going to look? And 2, we may have to think about how we communicate about transitional justice and what we're going to do in that period, because it may be sending the wrong signal and disincentivizing other people that we need to deal with. And 3, do we need to actually even review the reunification policies that we're pursuing in order to achieve the transitional justice that we want in the post-unification period? Thank you. With that, we'll open up the floor to questions. Please raise your hand. Troy, and then right there, we'll stick to.
Troy Sarah with KI. I have a few questions, and some of these are kind of like Abe's sort of maybe broad-based questions. But when we look at the situation of North Korea, other than perhaps the German example, most transitional justice take place when one regime is replaced by another. In this case, in theory, it would be the unification of a state. So, who is, justice for? Is justice for South Koreans? Is justice for North Koreans? Is it for a Korean nation? So I guess, could we define in the Korean case who justice is really for? And if it's primarily for North Koreans and what happened to them, should we be considering a process to where South Korea sets up and helps to facilitate a transitional justice process, but is not actively involved? In other words, provides guidance, provides support, but essentially is let it run by North Koreans. The other question I have is, the last panel talked about, that there could be multiple paths that states face. But it seems as though in situations like this, there's also multiple futures that states face. And that, as Abe was just mentioning, when you have transitional justice, you create incentives for basically society and the state not to be able to move forward. So how do you overcome the paradox of satisfying what was discussed earlier, the need for justice, and that people, yesterday I think it was Natios who said that people will seek it out if the state doesn't provide it, but at the same time creating an environment to where basically the state and society can move forward, achieve all the other things that need to be done in order for basically the country to move on, so that way you're not essentially a society living in the past. Thank you.
Thank you. There's a question right there.
Hi, John Dansler-Wolf from Ori Tours. We're at DPRK tour operator. I guess my question is, so in sort of our domestic justice system, there's a primary fact-finding is tasked to police force or FBI, some sort of law enforcement, separate from the judicial function or the representative function that a lawyer will play. So in the transitional justice context, who is tasked with primary fact-finding? Do we rely just on, I guess, searching through the rubble if there's a war? Or, is there a separate police-type force that does primary fact-finding? And do the identities of those people make a difference, or have they made a difference in the past?
Let me start with that last question and offer a couple thoughts about the previous questions by Troy. In terms of evidence collection, again, there are always going to be choices to be made. In the case of Cambodia, there was a hybrid. There was a Cambodian Genocide Project, an internationally funded, internationally staffed investigative arm that collected for many years information about the Khmer Rouge period and turned over all of that documentation to the tribunal when it was established. There were also Cambodian police who conducted investigations and information, as well as gathered documents from the Khmer Rouge period that had been salvaged. So it could very well be a hybrid, and whatever justice mechanism is established should, in essence, have subpoena power, to request and seek out the information that's going to be held in many different places. There's going to be information in U.S. government files. There's going to be information in Chinese or Russian or Japanese files that may be relevant to establishing trails of culpability and justice. I don't have the answer, but I suspect it's going to be a hybrid. And then briefly on the sort of the really great question Troy asked about should this process perhaps be run by the North Koreans if in fact the goal of justice is to provide justice for the North Koreans who suffered most directly. I mean, it's a really great question. I mean, are the people of South Korea going to want to have war crime accountability for Waipido or the Cheonan and seek as part of a truth and justice or transitional justice period, or for dozens of other war crimes? Are the South Korean people going to be seeking justice for abductions? Again, I don't know the answer. I would be very surprised if the scope of justice in a reunified Korea is limited only to the deeds of the North Korean government against the North Korean people. But in terms of scale and scope, I would expect that to be the focus. But I would not expect, since we are talking about one people, right? I would not expect that process to be handed over into the hands only of the North Koreans. I mean, I think that one of the beautiful things about Korea is it is, at the end of the day, one people. And the division of the peninsula is artificial. And if it's justice in the context of unification, I don't see how you exclude the South Korean people from participating in the seeking of justice for their North Korean brothers and sisters, as part of this transitional justice mechanism.
If I may, I'd like to add a few comments about mine. Well, who's this justice for? Well, I think it is not only for the victims or families, but also the whole nation. It is a kind of ritual bath. So, after the Manchu invasion, many Koreans, hundreds of thousands of Koreans were taken to Manchuria. And then some of them were ransomed and came back to Korea. And of course, the returnees included women who were regarded as assault or dishonored. And they were asked to take a ritual bath in a river. And then they were regarded as absoluted for anything that may happen well, I think the transitional justice for North Korea is a kind of absolution that is necessary for the nation to move forward. So it is something that should be dealt with. Well, to be frank with the South Korean transitional justice, it is also a kind of a ritual. Okay, although Dr. Beck emphasized the role of the civil society in reality in setting up these different commissions, these victim groups, the activist groups were instrumental. But once it is established, well, of course they had some influence on those investigators who were from their own organizations. But in reality, if you ask the ordinary the public, well, 7 or 8 out of 10 would say that this is a useless waste of resources. What is the use of digging up the past? So, in fact, this is more like a ritual for the victims' families, activist groups, and for the whole nation to forget, eventually to forget. So I would say if anything happens in North Korea, it would be as a kind of ritual. And the justice and the reconciliation, well, eventually reconciliation will be more importantly regarding in the process some justice, token justice will be pursued. But eventually reconciliation would be the national goal. That's my impression.
Yes, I want to add some points. Yeah, the justice for all the people on the Korean Peninsula and representing cases of crimes against humanity perpetrated by the North Korean regime would be not only political prison camps, but abduction of South Koreans during wartime and post-wartime abduction of South Koreans, Japanese, and many others. So it may expand to other neighboring countries. And about the North Korean escapee case, maybe China on the other side may include it in this project. But so we need to consider more that how to limit the scope of time and scope of the space. So it is another problem. So we need to consider it further. And we not only political prison camps and abduction, as you said properly, we have prisoners of war cases, and we also have separated family problems. So it is not just for the North Korean people's justice. But when we implement the transitional justice mechanisms, we should consider properly the sentiment of the North Korean peoples. But if they really willing to do their own justice, but the problem is somewhat ability. So if necessary, from now on, we may make some program to enabling them to do something about the transitional justice. Thank you.
Questions?
I guess my question is for Dr. Lee. Politicization of redress of transitional justice may be seen as a problem, but is that the function of politics? Politics may be reflective of diverse and contending opinions on interpreting difficult history. So in that regard, ambiguity, confusion can be regarded as a positive element. Flexibility, potential to embrace different opinions with a longer time horizon, especially when Unified Korea should immediately incorporate North Koreans as constituents, because according to the ROK Constitution, North Koreans should be able to immediately participate in electing their governments, electing their leaders. So I think ambiguity, confusion, lack of direction can be a positive element?
Well, I don't know. A certain politicization is inevitable. Well, in the first place, well, why did South Korea settle for truth commissions? Well, that's because of the issue is the issue of transitional justice may arouse big controversy in the society. It may divide the society. So they settled for a political compromise. That was a truth commission in the first place. Well, I tell you what, when I was the president of the TRCK, I was met the Minister of Justice to ask for some support, for step support. And he joked, actually very sarcastically joked that my organization was Supreme Court. Well, indeed, the problem is that in the case of Korean TRCK, well, our decision was absolutely upheld by the court. So the victims, if they file a retrial at the court, then a trial was granted, and they always won. There is no case in which the victim did not win. So, and then they go to the civil court, and they filed for they are demanding indemnity. And well, it is really enormous amount the government is spending on these indemnities. For example, up to the end of the April this year, the indemnity the government was ordered by the court to pay was 134 billion won. Okay, it may reach 200 billion won, maybe more, by the end of the year. So it is, in a sense, it is also a very big business. So some lawyers are actually living on these indemnity cases. Well, even unification takes place, and if it is a unification in the form of absorbing South Korea, North Korea, South Korea absorbing North Korea, then that is the worst case, I suspect. Because of the South Korea is the successor state, it will face, the South Korean state will face indemnity cases, compensation trials, cases, hundreds, thousands, tens of thousands. It is the worst case. It is inevitable, but, well, even when the decisions are political decisions, the courts are not acting in that way. Courts are, in a sense, are taking the laws, the letters, too seriously. So that's a big problem.
Let's take that.
Daniel Ong, intern with the Committee for Human Rights in North Korea. First, I just wanted to thank you all for your very instructive presentations. And to begin with, it seems in these discussions we have South Korean and the international community policymakers very well represented. I imagine in future discussions, as we're talking about transitional justice, we'll include the North Korean policymakers as well. And so based off that, I have two questions. The first is, how will we involve the North Korean community in transitional justice schemes when either one, as Dr. Kim alluded to, all the educated and upper regime have their hands soiled, or those who aren't as well informed may not have the capacity or maybe have been inundated in propaganda to begin with. So how do we include their opinions in a legitimate way in these discussions? And number two, how do we address tensions if there are conflicts between, or if there are disagreements between what the South Korean policymakers and North Korean policymakers would decide. It seems there's a clear hierarchy in between the international community in South Korea, if there's differences because South Korea is the one primarily involved. But if the North Korean government, which is interested in its own future as well as past atrocities, how do we resolve these types of tensions? Thank you.
Let's take one more question.
My name is Bert Wise, pro bono advocate, a lot of experience in the government. With regard to the truth commissions, as in some ways the best mode of titrating the demand for justice and the requirement of reconciliation, the poster boy is usually what Mandela was able to do in South Africa, but the reason why they were able to require the perpetrators of human rights abuse to essentially admit guilt and face their accusers and so forth was that they had the potential power, once the government came into place, to punish at least some of the perpetrators. And as Mr. Kim said, the question of how reconciliation comes about may not leave whatever the government is in charge with that kind of leverage for Truth Commission. And I was wondering what your comments were about that, but also there have been instances such as when President Aristide was returned to Haiti, where the U.S. government forced him, in violation of the Haitian Constitution, to try to grant amnesty to all of the perpetrators in a very bloody but much shorter regime of dictatorship. How would the people of North Korea react, the victims and the general population, if the international community, to effect reunification, required whatever the successor governing officials are to essentially provide some sort of amnesty?
Two great questions. So, how do we incorporate the North Korean leaks into this discussion?
If you look at the real-world cases, well, whether the amnesty is granted or not, eventually the demand for justice, the issue of justice will emerge, will become a big issue. As we see in Uruguay, Argentina, Korea, Spain. In Uruguay, the human rights violations were very pervasive. The most pervasive among the Latin American countries, but the Uruguayan military granted the amnesty to themselves, and of course there was a movement to re-signed the amnesty, and the issue was many Uruguayans signed for a petition, and the national referendum was taken, and it was defeated. But now there is another movement to recall the amnesty. So even when the perpetrators are granted amnesty, they may not be totally safe. So I think that if you have to choose between transition and justice, well, I would say you have to choose a transition, even if it may compromise immediately the justice, but eventually justice will be served. That's my observation of the real-world cases.
And just very briefly, I love hearing the word amnesty said repeatedly over and over again. And Amnesty International's view on this is not inconsistent with what I think all of the panelists have said. There has to be an effort made to define the scope. of justice. And Amnesty's view is that when you're talking about crimes against humanity, genocide, war crimes, widespread systematic violence, that there cannot be impunity, right? But that leaves a wide swath of lesser crimes, which could be dealt with in any number of different ways, which we've talked about today. And I think that in order to get buy-in from the North Korean people is very important. And in order to do that effectively, they're going to have to know that most of them are not going to be subjected to criminal prosecution. I mean, that's I think, an honest political assessment of a transitional justice environment in North Korea. And indeed, some truth and justice mechanisms hold that out there as a promise. Cooperate fully, allow this process to move forward, and we can present to you at the beginning of the process a sense of where the scope is. And if you don't fall within this scope, you don't have much to worry about, right? But if you're inside that envelope, then justice is going to find you, no matter where you're hiding. And indeed, I think that's going to be important, both for allowing a process of reconciliation, but also for getting to the truth. Because you need witnesses, you need support, you need buy-in from the North Korean people. I don't know this, but I will predict to you that all of us will be surprised, not only by the severity of the various crimes that have been perpetrated inside North Korea when we learn about them, but also by the rapidity with which many, many, many North Korean people will come forward to share their own experiences in the event of an opportunity to do so. And so I don't think we should think of justice as something to be handed to the North Korean people as a gift when the circumstances allow. My guess is that justice is going to be something that the North Korean people demand for themselves when they're given that opportunity. And that therefore listening to their voices and incorporating their desire for justice into the transitional justice mechanism will be very important for the success of it. And for the South Korean people to understand that the North Korean people are going to want to own a part of that justice mechanism, whatever it ultimately looks like.
So, yes, peace agreement between South and North Korea. Yeah, needs some compromises, some deals. So we may put more emphasis on TRC approach rather than criminal prosecution. But North Korean human rights issues has become already international issues, not just between ourselves. So although we may put more emphasis on TRC approach, the minimum prosecution should be pursued, at least about international crimes such as crimes against humanity and genocide. So but maybe there are unofficial solution about the secret escape to China for seeking asylum, about the North Korean counter regime, but it is somewhat confidential one. But the nominally we cannot give up any minimum criminal prosecutions towards the perpetrators. So without it, it is not peace agreement, just against peace agreement. Yeah.
I'm informed that I have a few minutes, and so let's just take two final questions, and that will conclude our session right here and then right here.
Michael Marshall, Global Peace Foundation. All the discussions to date have dealt with examples where authoritarian or totalitarian regimes were replaced by something democratic or at least more moderate. I missed the discussions earlier today, but in a contrarian mode, I wonder if there was any discussion of the example of Vietnam as a model, or not a model, but an example of a certain form of transitional justice, and are there lessons, either negative or positive, to be learned from that?
Okay. And final question here.
Again, I'm going back to the Eastern European example because I think it's important for North Korea. We are talking about a communist regime, and I think the North Korean communist leaders will look first and foremost to other communist countries and what happened in those countries, and then to what the U.S. and China and whatever. And although I see that you two are very optimistic about impunity, in the end we'll get them. And actually, I'm looking at Eastern Europe, and I wonder how the heck the international community can stand up the impunity that followed the collapse of the communist regime, because court trials were very few. They were botched. They were short trials like Ceausescu. They were except for Germany, where they had 2,500 trials related to the communist crimes. In all the other countries, when I edited a book about transitional justice in post-communist countries, there were very few. Impunity was the rule. Yeah, the communists were not brought on trial. They didn't need amnesty because in the end, no country was serious about court trials. I don't know if the international legal discourse has changed dramatically during the last 25 years. And I would love if this is the case, that the immunity is not there. But the record of dealing with or using court trials in post-communist settings is pitiful internationally.
Well, I do not want to sound Machiavellian, but there can be many different ways of dealing with this issue of impunity. In China, they have 36 stratagems. One of which is the so-called kill a person with borrowed sword. So use hired gun. So what? We may. So that's why we may need to engage the international community. Another possible way of dealing with this is divide and rule. So let one faction of North Koreans judge the other as other North Koreans using the North Korean laws. Okay, they may apply. It depends on how you apply the laws. So, I'm not Machiavellian, but there can be many different ways of dealing with this issue. I think transition is the foremost the requirement. Once that is achieved, then the rest will be much easier.
Professor Lee may not be Machiavellian, but both of our names end in vowels, so so we can pretend. And indeed, there are many ways that justice may come, and we've all said repeatedly. I'll say it one last time. The scenario will affect things quite a bit. If 4 dozen senior North Korean marshals, generals, and Politburo members are assassinated prior to unification, there may not be as many trials left to be had, and so it's going to matter how it happens. But I didn't mean to imply that the record is so encouraging. I would agree with the gentle lady that the record is not an overwhelmingly positive one when it comes to dealing with questions of impunity. And yet there are these inspiring cases. Heads of state brought before the International Criminal Court. Rios Montt in Guatemala. We'll see what happens ultimately, but convicted once, now the trial in a review period. But 2 decades, 3 decades after the crimes that he committed, brought to justice in an authoritarian state, not a communist state, but in an authoritarian state. Cambodia, again, a nominally communist country, agonizingly working its way through the Khmer Rouge tribunal process with international assistance. So there are examples of accountability, and I think that should be our objective. Even if the prospects of getting it are not always great. And then the Vietnam model is a really interesting question. I appreciate the question. Amnesty International would reject the Vietnamese model for its essential unfairness and lack of due process. In other words, that the North Korean state imposed a kind of a rough justice on the South. On the other hand, it can be said that model of justice, which essentially was an extrajudicial process of reform through labor, re-education, and arrests of large numbers of people for relatively short periods of time, and then a ritual bathing, if you will, and a reprocessing of them back into society. It can be said that was their own style of truth and reconciliation commission. Again, I would condemn it as fundamentally lacking in transparency, due process, and rule of law. But it is out there as an example of a process designed by a communist government with a principal focus on reconciliation and moving forward, rather than on forever jailing and imprisoning and detaining in perpetuity enemies of the state, the leaders of the South Korean government and the South Korean military. So it's an interesting example that's out there. I don't think that we should hold it up, as an example of good justice, but it suggests that the North Korean people, if left to their own devices, might nonetheless come up with a mechanism that would affect some measure of accountability.
Well, please join me in thanking the Asan Institute and their staff for a wonderful conference and our
On behalf of the Asan Institute for Policy Studies, I should thank all of you here in this room for your significant contribution to this conference. Personally, this conference reminds me of a joke that one of my friends told the audience in a conference whose working language is Korean. He said to the audience, in English, "Yesterday is history, today is present, and tomorrow is future." And then he said to the audience that if dealing with history, we do not, the present discussions do not provide any presence, then, tomorrow is not the future. Tomorrow will be nothing but mystery. So I hope this conference has provided us with lots of presence in order not to make the tomorrow of North Korea's human rights situation a mystery. Before ending this conference, I would like to ask you to give some warm applause to the staffs from the Asan Institute in Seoul.
Before we head over to our dinner reception, I would like to remind everyone that the Asan Institute will be hosting an event at the Reagan Center on June 24th and 25th, celebrating the 60th anniversary of the ROK-US Alliance. We will be sending out invitations to you very shortly, so please save the date on your calendar. And with that, we're going to head over to Smith & Wolonsky for our dinner reception. Please join us. It's right across the street, and it's on the second floor. Thank you very much.